Hi there. Thanks for tuning in to QuickTalk, the MedTech Startup Podcast. I'm Axel Strombergson, Vice President at Viva MedTech. Today, we're going to dive into law, startup law, specifically when it comes to medical device companies. And we're going to talk about things like how to form a company, what you need to do from a law perspective, all the way up to considerations when you're getting closer to an exit. With me, I have José Padilla, who's an attorney with extensive experience in this area, and he's also the owner of his own law firm, Padilla Law. Hi, Jose. Welcome to this episode of Quick Talk. Great to have you here today. As you know, we will discuss the legal aspects of a medtech startup, kind of from formation to later into the journey up till exit of sorts, right? But before we jump in, please share a little bit about your background and what you guys do at Padilla Law. And also, I know you work on this new thing called Legalmente AI.
Yeah, well, thank you for having me. Yeah, my name is Jose Padilla. I'm an attorney. I've been an attorney, graduated in 2000. I went to Harvard undergrad, Penn for law school, worked at the big law firms, then went in-house, worked for a variety of, healthcare related companies, and then started my own law firm about 5 years ago, where we have a small but growing team that's focused on supporting entrepreneurs and those that invest in them. And in addition to my law firm, where we do a lot of venture capital work, I have my own startup called Legalmente AI, which ultimately is designed to, may one day replace my law firm in that it does AI-powered contract review and other legal services that it uses AI to democratize.
That's really cool. Is that something that's available today? Or how far are you
Yep.
on the journey?
Yes, it is. You can go there to legalmente.ai and you could upload a business associate agreement that's in healthcare or an NDA, or if you're having an investment, a safe agreement, and it will review it in the way that I would review things and give you kind of notes and about what's good or bad about it.
Oh, that's really awesome. That's really helpful. All right. Yeah. So to dive into this topic of today, maybe just start off to talk about sort of generally speaking, sort of an overview of the type of legal support that you see that most medtech startups are needing, and also touch upon whether there is any difference when it comes to medical device startups compared to, say, consumer product startups.
Yeah, so one thing I want everyone to remember is that legal support, generally what it's talking about, it's protecting yourselves from liability. So what does that mean in real life? It's forming an entity which protects you from your personal liability. There's going to be regulatory and compliance issues, especially in med tech, where there will be additional regulations you have to worry about. There's contracts, which would be whether it's employment agreements, confidentiality agreements, customer vendor agreements, everything kind of designed to, relay, where the risks are going to lie. And then there's IP is all important, since your startup is going to be, the value is going to be derived from your intellectual property. So you got to make sure that that's protected legally. And then kind of probably maybe the most important is then the financing work, making sure that you get the money so that you can afford to pay for the rest of the things. And that is also, you'll need legal help to do that as well.
Right. And as it relates to med tech, is there anything that you see is sort of like different with the med tech startup that I also have to consider that maybe consumer product startup wouldn't have to deal with? Anything there?
Yeah, the main thing is that, medical technology is probably one of the most highly regulated industries in the US. If you're doing just basic software, there's really little regulation to worry about. But when you're doing a med tech, product, there's, in addition to the FDA, there may be other regulations. For example, you'll be dealing with, with R&D. You may be dealing with government agencies, and there's going to be government regulations on how to deal with, government agencies, or rules you have to follow to do that, to get a government contract, for example. There's also collaboration with healthcare professionals. If you're going to be dealing with doctors, there's a whole new area of regulation there with doctors, which includes, anti-kickback laws and HIPAA, because if you're dealing with patients, the doctors and their patients, then you're also going to be dealing with patient information, and then you'll be having to comply with that other kind of set of regulations there. And then on top of that, because MedTech is global, if you're successful in the US, or let's say you're successful somewhere else and you're coming to the US, you're having to worry about all of these kinds of regulations in every single country. So it's a very regulatory heavy kind of area.
Right, right. Yeah, awesome. So if you're a startup, one of the first things that you kind of have to do, at least from what I know, is that you have to form your company, right? So tell us a little bit about the type of structure that is typically used. I know there are LLCs and S Corp and C Corp and so on and so forth. So which one that that you should go with and why? And also know that there is some preference in terms of where in the US that you should form your company. So please tell us a little bit about that.
Yeah, I mean, the short answer is you need to be a Delaware corporation. The longer answer is, people may tell you an LLC is easier to deal with, may be cheaper in the beginning. And I'll just tell you that it's not really true. If you're an LLC, can you convert to a corporation later? Yes, you can, but it's not going to save you money. Also, there is a tax break that U.S. Taxpayers get that if you have a corporation and you have created the corporation, you hold it for more than 5 years. And when you sell it, the corporation has less than 50 million in assets and follows a couple other rules. And then it's called QSBS, qualified small business stock. And when you sell it, you pay 0% tax. So for that reason, if you're an investor, you will only invest in a corporation. And then the industry is pretty much coalesced around Delaware corporations. So that's kind of the easy answer. And then if you hear S Corp versus C Corp, just know that every corporation by default is a C Corp. You have to apply to become an S Corp. And with an S Corp, you cannot have a shareholder that's an entity. So that pretty much precludes any investors because an investor wants to invest using a limited partnership or an LLC. And so they won't be able to invest in an S Corp. So really, your only choice is a Delaware corporation.
Okay.
And one thing I want to note is there is one way to set it up, and because of that, my law firm offers Delaware incorporation at a flat fee of $500.
Okay, and that's everything included that you need to form and get an entity established there?
Yes, it's everything, including the initial stock issuances, the bylaws, all the initial kind of documents, so that you're essentially ready to accept investment after that.
And that's $500.
That's correct.
That's great. Just a quick follow-up question that I always wondered. So why Delaware? Why not Mississippi or California?
Well, Delaware has basically positioned itself to do that. They've created their own court system that is only for corporations. So unlike Mississippi or California, if you have a lawsuit, if you in any of these other states, that judge maybe in that morning was dealing with a divorce case, and then now they're dealing with your case regarding convertible notes and percent interest of your company. And so that judge may or may not know a lot about corporations. While in Delaware, the court system is just for corporations, and they'll be only dealing only with these kinds of court cases. They tend to go faster, and you kind of have more. And because they have that system, there's a lot more court cases and examples of what goes wrong. So what will happen is you go to Mississippi, there may not be a case as to previously about the same kind of dispute that you have.
I
So
see.
the judge has more latitude. The judge can decide how they want to. In Delaware, and basically in all states, the judges should decide how they've decided in the past. And with Delaware, there's so many examples of how they've decided in the past. You can know in advance how the court will decide things. That kind of certainty makes it really good for business because now you're certain as to what the result is, and it will prevent unnecessary lawsuits.
Yeah.
So
And especially then, I guess for investors, it's safer for them also then to make, if they know that you're in Delaware, they know these things and they have sort of it ties into de-risking their investment if you're in Delaware. Would that be correct?
that's true. And the other thing I want to mention is the whole venture capital industry is essentially designed around minimizing spending money on lawyers. So one of the aspects of this is if you are an investor and you're investing in, you have a fund and you're going to have 50 to 100 portfolio companies. And if you have a dispute in one and you spend money on a lawyer to find out what does the law say about this kind of dispute, well, you want to be able to use that legal opinion on all of your investments. And the thing is, if you have one company that's a Delaware corporation and one is a California corporation, well, now I have to spend money for a California lawyer to look at this, and I'm spending money again as opposed to spending money once. And essentially, all of my corporations are Delaware, and it's essentially a commodity, so that I don't need to spend money on lawyers every single time, and so it saves money.
Okay, awesome. So, speaking about investors and investments, I know that's an area where startups also need legal support in different ways. So let's talk a little bit about that. How do you support startups when it comes to fundraising?
Yeah, so I support startups really from start to finish, from formation all the way to getting acquired. And in between, when you're raising money, we help them whether it's using SAFE, which are simple agreements for future equity, which has become the standard. It was developed by the Y Combinator Accelerator. Pretty much everyone uses it now. And then there's the convertible note, which is a debt instrument. And then there's what they call a priced round, which what that means is the sale of preferred stock. And kind of what I said before, everything has been kind of designed around legal costs. So what you choose depends on legal costs. The SAFE was designed to be something that is a template, and you don't really need a lawyer. Now, lawyers have gotten their hands on it, and some people make changes to it, but generally speaking, it's a shorter agreement. It's pretty easy. And then the convertible note that has a debt on it is essentially like a SAFE, but it also includes interest and a maturity date. And so it's a little more customizable because of that. It costs more in legal fees to handle. And then the priced round, selling preferred stock, that is the kind of the most expensive form of financing when it comes to legal fees. And that is selling shares. And that gives the most rights to investors. So when you kind of go on that scale, you know, what's better for the founder? The SAFE is the best for the founder, then the note, and then selling preferred stock because um, the SAFE, the investor doesn't really have that many rights, doesn't have any control over your company. On the other end of the spectrum, when you're selling preferred stock, every stockholder has certain rights. And then in the preferred stock deal, they will negotiate additional rights in your company, for example, like a board seat. And so as a founder, that's kind of the spectrum as to control versus cost as well.
So I would say then, based on what you just described here, that when it comes to the priced round, that's really where you need some legal support, right? Someone that is in your court to then help with manage that control. Would that be a fair statement?
That's true. That's true. No, you definitely need a lawyer for a priced round, and you need one that's experienced in these kinds of venture capital financings. Again, because if someone's not experienced, they're not doing things the way that is normally done. And the venture capital field, people do things a certain, and like I said, a lot of the reason why it's done this way is to lower legal costs. And if you get someone who's not familiar with it, they make a lot of changes that may make sense outside of venture capital, but not in venture capital. And all it does is it causes more back and forth and more legal fees. And so that's why it's some investors won't allow you to use a lawyer that's not experienced precisely for that reason, because it'll increase the legal fees for everybody on the deal.
Mm.
So that's really important to get someone that knows what they're doing and can be able to explain it to you so that you understand what you're getting yourself into.
Yeah, and I'm sure also that would extend the timeline, right? So for a startup, time is of essence, right? So you don't want to have to go multiple iterations and negotiations back and forth. You want to have a pretty clean cut and move forward, right? So I'm sure that's a big part of it as well. Awesome. So if we kind of think about, we talked about forming a company, raising money, and then so the company can execute and eventually then get through FDA or get the CE mark or whatever. Once you are in commercial distribution, with your company, of course, the other legal aspects that you have in terms of your responsibility as a company and liabilities that you may have for that. Talk a little bit about things that you see once a medical device startup company then goes into commercial distribution and considerations for that that they might need help with.
Yeah, so well, one thing to note is, we've gone the long road of finally being able to commercialize. There's a lot of things you should have done beforehand, protecting your IP, which includes that making sure that everyone involved with your project has signed an NDA as well as an assignment of inventions so that everyone that's involved, making sure that all the IP belongs to the company. Make sure that you filed your patents for what you need, and that protects your IP so that now that you're commercializing, you're the one that has, and then no one else can come in and start infringing on what you're doing. And then, what you're needing is licensing agreements. Whether you're licensing it out to someone or you need to license someone else's technology to complement whatever you're doing as well. There's also distributor agreements as you're trying to just, either 'cause there's different strategies depending on what your sales and marketing strategy is. You may need distributors. So you have those agreements. You may need, to hire people. So then you'll need employment agreements. There's a lot of, it's kind of another area of, HR growth where you have to make sure, you're doing that correctly, that you're hiring someone as an employee or contractor. There's actually regulations around when you can call someone a contractor versus an employee, and then there's agreements around that as well. Um, and so, I think there's a lot of, additional, kind of the legal framework at that point is more as to, really protecting the money. And all these contracts, what I always, tell my clients is you got to see where the flow of the money is, and that kind of tells you how to make sure, like if you're paying money, you want to make sure that you can get out of that agreement whenever you want to. If you're receiving money, you want to make sure that that agreement is really hard to terminate. So
Okay.
those are the kind of things that you have to think about when you're looking at that, in addition to the fact of the risks and the liabilities.
Okay, that's great. That's really helpful. So then talking even further down the road, right? You're in commercial distribution, you're doing great revenue, and you start having a lot of interest from bigger actors and being also venture back. Typically, your investors want you to make an exit, right, of some sort, so they can get the money back. Let's talk a little bit about that. How legal then also plays a role when it comes to an exit of sorts, whether that's an acquisition or in rare cases an IPO.
Yeah. So, nowadays IPOs are more rare, but most companies will be looking at acquisitions. And with an acquisition, the critical part actually should have already been done. So everything I talked about before, a lot of these contracts, if you have everything in place already, all that is made to really increase your value, to get the most money back. Because when I represent a buyer, my job in looking at a company is looking at all these agreements that I discussed before, looking at the patents they have, looking at the employment agreements or the assignment of inventions. You look at an employee list, make sure everybody has agreements that where they assign the IP to the company. The whole point of looking at all these things, making sure that you're correctly formed as a Delaware corporation, that you've followed the legal requirements for a corporation, and you've paid your annual franchise tax with Delaware. All these things we look at, and part of the point of it is to come back to my client, the buyer, and say, hey, here's some things wrong that can allow you to now actually lower your price. So that's where it's critical that you have an attorney along the journey to make sure that you have everything set up so that when it's time to sell, they can't ding you, this way or that way because you have something that causes an issue. For the most part, I would say most things can always be corrected, but those corrections always cost money, and it always costs money to correct things than to just do it right the first time. So that's the thing to kind of remember.
Okay, so it's really about, setting yourself up for that future success by doing it the right way. So when that time rolls around, there's not a whole lot of gaps and things that they can just kind of, use in terms of bargaining on the acquisition value, basically. Okay,
Yeah,
that's
I'll give an example of just a quick example. One thing, sometimes maybe the price won't change, but what they can do is they can add an escrow or increase an escrow. And basically, what that is, it's saying, let's say I agree to pay you $10 million for your company, but instead of you receiving $10 million on closing, I'm going to set aside $5 million in an escrow, and that's going to be there for a year. and you're not going to receive that because I want that money as a buyer. I want that money in case some of these things, some of these problems pop up and cause damages. That money, those damages come out of the 5 million, comes out of your pot. It doesn't come out of my pocket. So,
Oh.
and as a bot and as a seller, you want all that money day one.
Yeah, you want to, yeah, for sure. Okay,
Yeah.
that's really insightful. Thank you. So what we've discussed thus far, right, is sort of your view on best practices, how you should approach this and do the right thing. In your career, what are some of the mistakes that you have seen a startup do that might also be worthwhile to talk about here for people to learn from? We've talked about the do's. What are some of the don'ts that you have encountered in these type of situations?
Probably the most common is I will see companies who are formed as LLCs. And one issue, I mean, one thing I'll start off with saying that every mistake you can fix. I mean, you can always fix it. The problem is you got to pay a lawyer to fix it. And that's no one wants to pay me, no one wants to pay me. So, so um, that's why it's always better, to do things right the first way. But so what I see commonly is, people form as an LLC, and then they sign a bunch of contracts. And then now I need to convert to a corporation. And some there's some contracts, like government contracts, they won't allow you to move the contract to a corporation.
Oh,
Or put it this way, they won't allow you to move it to a different entity. They don't care if it's a corporation or LLC. It needs to stay with the same entity without signing a whole new contract, which also means whole new contracting process. So you
mm,
don't want that. Once you've gone through the government contracting process and you got your contract, you want to keep that.
right.
So what happens is that just creates it creates some complexity and then how you have to set things up. And you usually have to keep that LLC in place and do a corporation. There's solutions to it, but it just costs more money. So that's a really big mistake I've seen often with MedTech because a lot of times you'll get these government contracts or these grants, and they're based on contracts that'll be with an entity. And sometimes you have to realize it's going to stick with that entity. So it's better to just form it right the first time. Another common mistake is just going to be the lack of documentation. I understand with founders, you have so many things that you have to worry about, but documentation is really important. And one example is your cap table, your ownership. I've seen some founders who they just promise a lot of people a lot of different stock, and they don't keep track. Or they promise people stock, for example, and there's taxes that you have to worry about if you're handing people stock. That's the reason why there's stock options. Stock options are tax advantaged. But then to issue stock options, you have to set up a stock option plan, and that costs more money. So then what I advise my clients is what you can do is do promised stock options, which essentially is just an IOU. It's just in the contract, you just say, I promise to give you stock options when I set up my stock option plan, and it's this many stock options. But you make sure that everything's written down, and then you keep track of it on your cap table, so you know how many shares you've promised the people, how many shares that people expect to have, so that when it comes time to do a price grab, for example, everything's there, or if it's time to sell, everything's organized. You know where everything, everyone knows where it's at, because what you don't want is someone to come out of the blue and say, hey, you owe me more, or you owe me this amount of money or shares. And I promise you, people come out when you are successful, not sure. When you're in the beginning, people may stay quiet. People may have problems with you, but they're not going to say anything because it's not worth any money. When you start making money, everybody comes out of the woodwork. So that's why it's important to have everything documented from the beginning. And the last thing I wanted to mention is the other important part is your IP. And the critical thing with the IP is that anyone who touches your IP should be signing an assignment of inventions, which means that they're assigning any ideas they come up with, anything they worked on, any IP that they created, it's assigned over to the company. And that includes like some advisor. And even if they're helping you out for free, they should still sign it because again, they may help you out for free. They didn't say anything. Now it's worth a lot of money.
Mm.
Then they're going to say, well, actually, it's not for free anymore. I'd like to be paid.
All right.
So,
Awesome.
so that's
Great. So we're getting to the end here. This has been tremendously helpful. A lot of insights here for sure. For our audience that want to learn more on this subject, do you have any recommendation, like online resources, any books, and so on and so forth? And also, how can they get hold of you and what you do if they need support from you specifically?
Yeah, well, they can go to my website, which is www.padilla.law. That's Padilla.law. And on there, I have various articles written on basically the most common questions that founders ask me. I've written an article about it so that, it kind of answers it so that people can learn about it more. And then my email address is jose@padilla.law. And then my contract review, AI powered contract review software is at legalmente.ai. Just legalmente.ai.
Very good. Well, thanks for sharing that. And I will go and check out your resources and learn some more on this topic. But with that, again, thank you so much for joining me here today.
Happy to be here. Thank you.
If you enjoyed this episode of Quick Talk, hit like and subscribe. And for additional educational content, visit our website at quickvault.viva.com.